Welcome to The Explainer. Today we're going to break down one of the most powerful lines ever drawn in the sand, the Fourth Amendment. It's the thing that stands between your personal, private life and the power of the government.
But before we dive in, let's just focus on one single word, because it's at the heart of everything. Unreasonable. What does it actually mean for a police search to be unreasonable? People have been fighting over that question for centuries, and it is the key to understanding this entire right.
Okay, so to really get the Fourth Amendment, we have to go back in time. Back to a time when a king's power could walk right through your front door. And the idea that your home was your castle was, well, under attack.
So back then, British officials had these things called writs of assistance. Now don't think of these as warrants. Think of them as a blank check. They gave government agents the power to bust into any home whenever they wanted for pretty much any reason. To the colonists, this was the absolute symbol of random, unchecked power.
This resistance didn't just pop up out of thin air. It was built on a long history of English law, like a 1604 ruling that said a man's house is his castle. But the real boiling point was in 1761. A lawyer named James Otis gave an electrifying 5-hour speech railing against these writs in Boston. That moment, and Virginia later banning these general warrants, put the colonies on a collision course with the crown.
And the impact of that speech? It was huge. John Adams was sitting right there in the courtroom, and he said later he didn't just see a legal argument, he felt like he was watching the American Revolution being born. For him, the fight for privacy was the fight for freedom.
So after winning a war that was literally sparked by these kinds of searches, the founders were dead set on making sure that no new government could ever have that kind of power again. And their solution was the Fourth Amendment. So let's just look at the text itself. The first part is this big, powerful declaration. It sets up a right for you to be secure in your own body, your home, your papers, your stuff, from any search or seizure that is unreasonable. That right there is the core idea.
So you can basically break the amendment down into two main parts that have to work together. First, you've got the reasonableness clause, which sets the big rule: no unreasonable searches. Then you have the warrant clause, which gives us the main tool to make sure a search is reasonable, a specific warrant backed up by probable cause.
And that brings us to the real gatekeeper of the whole amendment, probable cause. See, to get a warrant, an officer can't just have a hunch. They have to show real facts to a judge, enough facts to convince a reasonable person that, yeah, a crime has probably happened, or that they'll probably find evidence there.
Okay, but here's where things get, well, complicated. The rule is supposed to be, get a warrant. But in the real world of policing, the courts have said that's not always practical. And that has led to a very long list of exceptions.
So let's run through some of the big ones. Consent is the easiest, right? If you say yes to a search, they don't need a warrant. The plain view rule lets them grab illegal stuff that's just sitting out in the open. And cars? Cars are a whole different ballgame because they're mobile. Then you have emergencies, what the law calls exigent circumstances, that let police act right away. Each one of these makes practical sense, but they also represent this constant tug of war between police needs and your personal privacy.
And this all leads to the most important question of all, doesn't it? A right is only as strong as the penalty for breaking it. So what happens if the police just ignore the Fourth Amendment and do an illegal search anyway?
Well, the answer is a powerful and really controversial tool called the exclusionary rule. The Supreme Court came up with it way back in 1914, and what it says is this: if the government breaks your rights to get evidence, they can't then turn around and use that same evidence against you in court.
But wait, it goes even deeper. It's not just the evidence they find in the illegal search that gets tossed out. It's any evidence they find because of that first illegal search. They call this the fruit of the poisonous tree doctrine. The illegal search is the poison tree, and any evidence it leads to, that's the poison fruit.
But you can see the huge controversial problem this creates, right? If an illegal search turns up undeniable proof of a terrible crime, why on earth should we throw it out? Why let a guilty person maybe walk free just because, as one famous judge put it, the constable has blundered?
Well, the answer really depends on why you think the rule exists in the first place. And there are two big competing ideas. The modern Supreme Court mostly sees it as a way to deter police, to discourage them from breaking the rules. But the original idea was about something else entirely: judicial integrity. The idea that our courts shouldn't get their hands dirty by using unconstitutional evidence no matter what. So it all boils down to this one question: is the exclusionary rule just a practical tool for managing the police? Or is it a fundamental part of the Fourth Amendment itself? If it's just a tool, well, it can be bent or weakened. But if it's a core principle, then using illegally obtained evidence is always a violation of the Constitution. Period.
Which leaves us right here, with this central conflict, pitting our collective need to be safe from crime against our individual right to be safe from the government. And as you can see, there is just no easy answer.
In the end, how you answer that question, whether you think it's more important to stop police misconduct or to uphold the integrity of the right itself, is what defines the real-world power and meaning of the Fourth Amendment today.